do the math, initially there are, let's say there's 600 apartments that are planned for the first part of this construction, 300 in a building at 535 Vanderbilt, and the other one in a building at the corner, 535 Carlton, the other one at the B3 site at Dean and 6th. Let's say those are completed, but nothing else happens after that, so there'd be 1,650 apartments left over. If those were not completed by 2025, $2,000 a month on 1,650 apartments is over $3 million a month. And that's a crippling level of damage for the developer. And although it's not mentioned here, if they were unable to pay those damages, that would be a default under the master development agreement, and they could risk losing access to development rights for the site. So these are very, very significant damages to ensure that the project really does get done by 2025, and if it doesn't, it's very likely that you'd see a change in control.
And what's important here is that all of these things are not agreements between the signers of Brooklyn Speaks and the state. It's the agreement between, or the developer, it's an agreement between the developer and the state of New York. It's in that contract. It's separate, it's different than the community benefits agreement. That was an agreement between community groups and the developer, whose enforceability is questionable. If they fail on this, they're failing on their contract with the state of New York.
Are we allowed to ask any questions?
Yeah, we're going to get to that. Absolutely, we'll be happy to answer
It's
as
just
many as
that
we
the
possibly.
figure you had about the 10 million, I was wondering how the $10 million of liquidated damages relates to the $2,000 per
They're
month.
separate.
There's
the two separate ones.
Two separate
Yes,
liquidated
those are-
damage.
They're separate.
Uh,
This has to do with starting the first 590 units. If they don't start them by June of next year, they're potentially liable for $10 million of LDs.
Right, up to.
all right, so there's some teeth to this.
There are some real teeth
We tried.
on both now and later.
And there is one, I don't think we talked about the middle tooth, if you
Right.
will. There's a middle tooth, which is, so going back, so then there's the liquidated damages if the construction doesn't begin of the 590 units, and there's the liquidated damages if they're not completed on terms of the affordable units by 2025. There's one more, and it's in the middle, and it's we call it the threshold requirement. So in total, the project is supposed, 35% of the project should be affordable housing. That was the original statement to the public back in 2006 and 2009. And so basically, in order to ensure that not all the affordable housing is front-loaded and not all the affordable housing is back-loaded, and that there's some construction of affordable housing in the middle, there's a requirement that as the units are constructed, that the threshold requirement is maintained. So 35% of the units must be affordable housing during construction until 1,050 units, and then it's allowed to drop down to 25%, but at the end it must equal 35% again. And if that threshold requirement isn't maintained in that way, the developer is not allowed to complete one unit of market rate housing until they get back to the threshold so that the affordable housing percentage is maintained.
And the threshold levels are not dependent on disputes with contractors.
Right.
So if you look at what's going on at B2 now, that will evenally become an issue, could become an issue on the threshold if
Again, we hope none of these things actually happen. And I think they don't either, right? So the other piece of this, so going back to the fact that groups like Fifth Avenue Committee and Pratt Area Community Council, that actually assist individuals who are facing eviction and displacement pressures, and in general, large-scale projects have been shown to increase displacement pressures. And so the thinking was that the developer should contribute towards services that would be provided to individuals in the community to prevent eviction and displacement. Now, obviously, this is very little, very late, but it is better than nothing. And so what we were able to negotiate was that a $250,000 contribution, one-time contribution, be made to the Brooklyn Community Foundation, and they will basically fund local organizations doing eviction prevention work and anti-displacement work in community boards 2, 3, 6, and 8. Again, having the effort focus. I mean, it'll amount to like 1 year's of funding, honestly. But
I think we actually covered this before. This has to do with the liquidated damages being paid to the New York City Housing Trust Fund.
there's a second half of this, though. So, the city of New York is very much involved in this deal, despite the fact that the state of New York oversees the project. And that is because the subsidy dollars would come from the city of New York. And with those subsidy dollars come some preferences that have been in place. So one of the things that we requested that the city of New York indicated that they would review is that folks that have been displaced from community boards 2, 3, 6, and 8 would still maintain eligibility for preference in the lottery for the affordable housing. Again, because so many people who would love to stay in the community and remain in the community have, had to move. We thought that was an important piece. And right now there is a discussion, I guess you could say, going on between the city of New York and HUD about whether or not the city's preference, community board preference, is actually something that complies with fair housing. So whatever, we'd have to see how that turns out in order to know whether or not this request can actually be honored.
So I think probably some of you are familiar with this. As part of the settlement, in addition to the performance criteria and remedies that we've been talking about, ESDC agreed to set up the Atlantic Yards Community Development Corporation, which is dedicated to overseeing the project's compliance with its public commitments. And this includes all of the commitments in all of the project agreements, not just the affordable housing commitments that we've mentioned, but also the commitments for environmental mitigations of construction impacts and the like. This is will be a subsidiary of the Empire State Development Corporation. We'll have a board of 14 members. 9 will be appointed by the governor, and 5 will be appointed by local elected officials. And I believe there was a meeting here last week with some of the local elected officials where the CDC was discussed. This is the first time that there has been local representation in any part of Atlantic Yards oversight. The CDCs must be established by the end of the year, and we required as part of the settlement that they commit to establishing it by the end of the year, because that is when construction will start to intensify again with the buildings that are coming on this block, and eventually with the building at B3, which will start in June.
Excuse me, and what's the teeth behind this? Because at the meeting it was unclear to us.
Right. So we'll talk. We'll talk about that. But just to understand kind of the composition, all board members now. Those of us who've been working on Atlantic Yards for a number of years know what the ESDC board meetings are. We know that most of the board members don't live in New York City, let alone live in Brooklyn. We do have a requirement that the CDC board members live in New York City. The board must meet quarterly. It's subject to the open meetings law, and ESDC must provide staff support and administrative expenses to run the CDC. Now, when you talk about what the teeth are of the CDC, the Atlantic, they are basically the commitments in the Atlantic Yards project agreements. So the Atlantic Yards project agreements include everything from performance from building the project to how the project is supposed to be designed, how the space will be programmed in terms of buildings, arena, open space, and the like. The CDC is responsible for overseeing all of that and has a fiduciary obligation under the public officers law to report violations, to report potential noncompliance or violations of those commitments to ESDC. That's a significant responsibility, and particularly when you consider that there will be people who not only, live in New York City, but actually people who are appointed by our own local elected officials who will have these roles and will have some insight into what is really happening on the ground here that would not be possible or expected for, let's say, the folks who are the directors of the ESDC today. Beyond that, the CDC is responsible for monitoring quality of life issues. These aren't necessarily, these are things that really go towards making the project over the life cycle of its construction and operation integrate with the community, and that could include things that have not been foreseen in the EISs, likely will include those sorts of impacts as well. So this is an ongoing chartered agency of the state of New York, including local representatives. Another very important piece of this, and it's a piece that I think probably bears bringing to the attention of city government and our local elected officials, is the second bullet, which has to do with assuring effective communication between developer, government agencies and officials, elected officials, and yada, yada, yada. For those of you who were here in 2010 to 2012 when the arena was under construction, very familiar with the level of construction impacts and the problems in compliance that existed at that point. One of the real issues in Atlantic Yards is that it's a project overseen by the state of New York, but those kinds of activities, construction activities, are actually overseen by agencies of the city of New York. And so there's an important coordination function that was desperately lacking during the arena build-out. And certainly when we negotiated the creation of AYCDC, our goal was to have an organization that would be able to coordinate centrally and understand what impacts and what issues in terms of non-compliance were taking place, and be able to triage and manage them with the city agencies like the Department of Buildings, the Department of Sanitation, the Department of Environmental Protection, Police Department, and the like. So that's the vision for AYCDC. I think right now, in terms of, we'll talk about this later, but some of the things that we need to be messaging to our elected officials now is that it's very important that there's a focus on that coordination, because that's going to have a major effect in terms of managing the construction experience once that starts again. So here, we want to talk a little bit about what it is. So, we just talked about all the things that the state gave up and the developer agreed to and everything else, right? Well, we had to agree to some things too. And this is what they were. We agreed not to pursue the legal claims that we had in front of us as of June 27th, 2014. And those were basically two things. The first was the claims of violation of federal and state fair housing laws that we described earlier. Obviously, that was the basis for us settling with the state and with Forest City, and so we settled those claims through the concessions that we just talked about. The second were claims against the 2014 SEIS. The SEIS was approved by ESDC at the same time that this settlement was announced. We had obviously spent a lot of time commenting on the draft scope and also commenting on the draft SEIS as well. We believe a lot of that commentary had a positive effect. It did result in some changes to the final SEIS, but we agreed not to do what we, file what was called an Article 78 suit, like we did in 2009, challenging the validity of the environmental analysis. So why did we agree to that?
Start?
Yeah.
Listen to our attorney.
Yeah, the goal of a lawsuit would be, ultimately, the request of the lawsuit was going to be to accelerate the development of affordable housing. The violation, the civil rights violation, is the delay. The disparate impact is because of the delay, the affordable housing units become available later in time. As part of gentrification, the people the folks in the neighborhood that would be available for affordable housing are being forced out. And as time goes by, those in the neighborhood that are eligible for affordable housing are becoming more white. And so ultimately, the goal of the lawsuit was to accelerate the affordable housing to ameliorate, the civil rights violation in our view. The settlement accelerated the affordable housing and ultimately avoided what we have here is the uncertainty of litigation. Any lawsuit has inherent risks, and one of the major risks in a Civil Rights Fair Housing Act lawsuit these days is that the Supreme Court seems to be very interested in whether disparate impact claims are going to be viable going into the future. So there's a lot of uncertainty in a lawsuit and time that's going to take. And not only the uncertainty of just winning, but the uncertainty of what would the judge, if we won, award. Would the judge award some kind of oversight, not a community type oversight. If any type of oversight, it might be more limited. So the question just became, what's the uncertainty, what's the risk versus the certainty of what the settlement got. And as I was noting, the oversight that Gib described here is not the type of oversight that a court would likely enact. And so for that reason as well, it seemed like a good idea to settle.
And when you think about our previous experience in litigation, when we challenged the 2009 MGPP, we really waited almost 3 years for all of the appeals to run out. When we looked at that here, and together with the uncertainty about what a judge would award, and a lot of doubt, quite frankly, that we would get representative oversight. In fact, we didn't have any expectation of getting representative oversight from a court order. We knew that there was no way that we would be able to get any oversight, any additional oversight in place by the time construction would begin in December or January if we went to court. We would basically be in the same situation we were in 2010 when the arena was under construction. We were in litigation with the ESDC and for City Ratner at that time. They were not amenable to discussions with us for all intents and purposes. And we really sat deadlocked while there were tremendous construction impacts. This time we felt we had an opportunity to be able to put oversight in place before construction began, or at least around the time construction began, and that opportunity was significant, especially considering that a court case would have taken many years to resolve. And then the final piece, having to
Can
do...
I just mention one more thing, and you have to remember too that the context or the other piece of informing that was that the Atlantic Yards Governance Bill, which some member Jeffries originally wrote and was able to remember 2007, we were able to get it passed in the Assembly, but not the State Senate. And then some member Mosley reintroduced it. State Senator Montgomery was a supporter on the Senate side. The uncertainty of what's going on with the New York State Senate, there was another piece as well about what kind of whether or not that legislation had any ability to actually make it through, New York State. And so the other piece of this was whether or not we can't get oversight through that mechanism because of the uncertainty, the political uncertainty. This was an opportunity. Why not try to seize it? Because it was, very much a very similar bill.
And I think it's fair to say we thought our opportunity to pass legislation to reform oversight by this point was very, very limited. And I read Norman's account of the meeting that was here last week, and I think Assemblyman Mosley, who introduced the bill last in the spring, basically felt the same way. If we thought it was difficult to get the bill through the Assembly and through the Senate, once we sat down and started negotiating with the people on the governor's side, we were absolutely convinced the governor would never, ever, ever sign such a bill. And so, if we had continued to try to force reform of project oversight through legislation, I think it would have taken a change of administration and probably a very different kind of governor before that would have happened. So for all those reasons, we believe that the opportunity was very significant.